So we should be starting now. Just waiting for the live stream to what is it that the lawyer on all across the planted something fields of the internet. Uh, let's see here. Yep. Okay. So we are live. So, just to recap, Lane Myers was arrested on violation of probation. I believe that was on July 9th, 8th or 9th. The case was reassigned from Griffin to Judge Metcalf, who was the original presiding judge. On the 7th or the 8th. Wayne Myers had filed a motion to modify conditions of probation on June 14th. That was later denied. He had his initial appearance under Rule 27.8A on July 13th. There was an order to set a hearing on media requests on the 22nd. That was denied on the 23rd. There was no written record in the minute orders for any justification for that denial. On July 28th, they amended the petition to revoke probation. Hearing on motion to modify, motion to dismiss was also on the 28th. A second amended petition violation was August 10th, which seems very telling since August 11th was the violation hearing starting at 9 a.m. So, just for the record, I went to this court to watch this hearing because I'm involved with a petition with the Supreme Court of Arizona. And that matter is competing with the petition by the task force, and then the one before that, which was filed by Matt Walker. Apparently 161 people have viewed this thread. That doesn't mean that they actually read any of the content, and of course there's been absolutely no replies, so it's kind of like a shunning effect, because I'm not a lawyer. I'm not in the in-group crowd. So I'm like the outsider trying to look in. And since everything to do with legal stuff is all about money when it boils down to it, you trying to save a buck and do it yourself is completely shunned. So that's why I originally started attending. And the first day I ran into some problems with ReallyCoolNews. We have this is Judy, Chief Bullshit Officer. She claimed that I was recording and broadcasting the hearing. That is not true. They have since printed a retraction or aired a retraction. Although they still claim that a police officer said that I was the one doing it. I have my doubts to that. I think she was completely misunderstanding the situation. In fact, I wasn't even sitting behind her. She was sitting in the second row. There's a woman behind her in the third row. And I was sitting in the fourth and final row. And I always sit in the far back because I don't like people sitting behind me. So, That's pretty much where the sitting was. And then she said that my phone or something rang, and that's not true. It was the woman in front of me behind Judy's phone that rang, and then she had it actually connected to a watch, and I think it was the combination of the watch and the phone that was ringing. It might even been one of those features where if you turn off the phone, the watch like thinks that you forgot your phone, and so like it's phone reminder. Because it happened fairly quickly. It was like a within the first 5 or 10 minutes, I think, of the hearing when everybody sat down and it started. Um, so that was then attributed to me, and she did leave after the police officer made her go out in the hallway to figure out her phone situation. I don't believe she ever came back. If she did come back, she didn't come back after the break or lunch. So she was transient, whoever she was. And I don't know who she was. I don't know her name or anything like that. So then somehow Judy, with all her note taking and journalistic integrity, got all of this wrong, and then accused me of falsely recording. And then she also said that I was some sort of creeper or something, trying to get into the elevator with her, which, I mean, really, if you think about it, doesn't make a whole lot of sense since it's a public elevator at a courthouse and the hearing just got over with. So a lot of people are going to use the elevator potentially. But that was somehow attributed to me as being a creeper or something. And then, of course, there was the interim after the phone rang and stuff like that. I told the lady that, Judy was the enemy because she worked for Really Cool News or whatever, some sort of association there. And I called that one. I fucking called that one completely. She is definitely one of those people that, if you don't believe what she believes, then she's going to go after you and you're not worth her time and oh my god, you're an idiot and all these other things. Like, she has no respect for anybody because they have a differing opinion. So I imagine she's kind of like racist and against various religions and stuff because, she probably has her own beliefs, and then there's other people with those beliefs like Buddhism and Islam and Christian, Catholic, blah, 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 blah. Those are all different beliefs. And the way I see it, God can be all things to all people at all times, all at once, because of perspective and limited access to the world through your eyeballs and your perspective. And then there's the history of time. And somebody like Judy couldn't possibly do that because, as she shows, everything's about her narrative and her being some sort of political and activist, where it's a war. You're not looking for the best ideas. You're looking for your ideas to be implemented. So, I never really wanted to go online and post these videos and have a public spectacle, but Really Cool News has ruined my privacy in that regard, and they are most likely intending on continual harassment. When I filed stuff with the Chili DeCastro Las Vegas Police Department, I filed a motion to intervene. They went after me there and was telling me, or talking about how dumb I was and didn't know what I was doing. Even though the first documents I filed were a motion to intervene, interventory complaint, and informa pauperis motion or application to proceed without the prepayment of court fees under 28 USC 1915. But I was an idiot even because they never actually docketed any of that. Uh, what they did was they docketed everything out of order, and then it looked like I wasn't doing what I was supposed to. But as soon as I filed a motion to intervene, I do believe I had a right to reply to what was going on, which is why they posted my motions in reply to like the motion to dismiss, and then they never docketed my motion to intervene. And then really cool news goes off on a tangent about what I don't know anything. And so when I filed a motion to intervene with uh, in Lane's case, and let's see if I have that. Um, let's see. Um, you do not want to do that. Hang on one second. I'm trying to find the motion to intervene on Lane's behalf. Well, no, not on Lane's behalf. That would be the unlawful practice of law. It was in his interest, but not just his interest, which is why I need the motion to explain it. Oh, I wonder why I can't find it. It's called Myers, not Lane. See if this works on shooting it to the computer. And KDE Connect is apparently not running. Am I on the wrong network? No. Why isn't it connected? Interesting. Sorry, still having technical difficulties on that one. So, let's see. Let's try it this way. That way, so I'm not broadcasting my email. So this was filed in so it's a motion for leave to participate as a public interest amicus or interventory, and basically the charge itself is the argument. What I'm saying with this is I'm going off of the recent Supreme Court case Hunter. That was this case here. It was decided June 18th, so it is brand new case law. And the holding was an agreement not to appeal a sentence is unenforceable when it would result in a miscarriage of justice, meaning when it would leave in place the kind of egregious error that would bring the justice system into disrepute. And everybody voted for it except for Thomas. So that's an 8-1 split. And basically, what I'm saying with this motion is we have the same thing here. We have a case that was overcharged. We have 20 counts. All of the harassment and stalking charges, and I'm not even saying that there isn't something there. I'm saying that if there is something there, they should have all been one charge. There should have been one stalking and one harassment charge, and there should have been two cases maybe on that, or just consolidated all into one case. Instead, they had like 20 charges split between 2 cases, and I mean, they were all repetition. There was stalking was in there 2 or 3 times. Harassment was in there like 12, 14 times. And then you had like interference with court, basically being an asshole, and a couple other charges that were misdemeanors. And then the plea deal, they got rid of everything but the stalking and harassment felonies, and he pled guilty of it. And then he was subsequently convicted after pleading and admitting. The judge found under Rule 17.3 a basis for finding guilt. And that's what I say that this whole motion is about. Actually, I think I can make that a little bit bigger. So here I lay out the foundation of the coercion, which is directly from Hunter. The fear and costs directly implicate the judiciary. They talk about how the justice system has been replaced with the plea deal system, and they're starting to lose integrity on the appearance standard. And so I focus on the no legitimate purpose. So the story here, and I mean, I don't have no ill will against the victim in Lane Meyer's case. I completely understand the position that she was in, somewhat, since ReallyCoolNews likes to, harass people using YouTube, which is exactly what Lane Myers was doing. So, I mean, if you want to use the word harassment, ReallyCoolNews is just as guilty as Lane Myers. But, I do need to prove how easy it is to find her name and how that cat is out of the bag. So, who is and what is the name of Lane Meyer's victim? And the way AI works, until you scrub the entire internet of these data and connection points, like this one, these here, and these here, AI is now built into Google search. This is actually AI mode in a little window, right? So I can ask it more questions. But I mean, clearly the data is, and it's just not possible to put this back in the box. That all this stuff has happened and her name is forever going to be linked to it. And who is her The victim, blah, blah, blah. Her husband, Matthew Walker, right here. So here it is. Even based on how you ask it, you get different responses. But and then, I mean, who is the wife of prosecutor Matt Walker, Tucson? Boop, boop, boop. I mean, this stuff is never going to go away. And then, oh, that's even hilarious. Okay, so I think it's the saying that Apex talks about. Okay, there's his wife's name right there. So the APAAC can put that information out there, but everybody else who does it is stalking, harassment, and otherwise just an illegal douchebag. Anyways, my point is, with that, that information is not going anywhere. The way AI and search tools work, and data points being out there, and how you can't delete anything from the internet, it's just a matter of fact. In fact, my name is now linked to this damn case, even though I had absolutely nothing to do with it except for I was some bonehead in the courtroom listening to it. So, if you look at the argument implied in the charges is that there was no legitimate purpose. And so the way that argument goes is basically the only reason why you were talking to Shannon Walker, the wife of Matt Walker, was because Shannon Walker is married to Matt, and Matt was prosecuting you, so there's no legitimate purpose there. I'm sorry. It is, how long has it been customary in news gathering to speak to the spouse of the news topic? Journalistic interview developed in the late 19th century, roughly between 1860s and 1880s. Early newspapers, Civil War era, human interests, wise spouses are interviewed, emotional context, personal insight, evolving standards. Okay, so there you have it. It's standard news gathering to engage the wife of the subject of the news article. Just like when Bill Gates had his Epstein episode, the first thing they did was talk to Melinda Gates. Same thing. No one arrested all the reporters for harassment of Melinda Gates and stalking for trying to get the news topic in the story. But, of course, you can arrest Lane Myers for that. And apparently any other person that isn't big enough to have lawyers and a news company and all that behind them. So, in order to convict on those two felonies, you have to beat the First Amendment and basic freedoms minimum bar. And that's what the no legitimate purpose is. Okay, so the constitutional line is true threats. It actually gets worse than this because basically in one such case, and I have that on my phone. Let me pull up. So it was case number C240290001 and C2409002 docket numbers CM24019676 and CM24019677. I think one of those was that auto parts store, or whichever one it was, O'Reilly's or the AutoZone. It doesn't really matter. And then there was, I think the other case is the booing at City Hall. So this was filed by Matthew Walker, and let me verify that before I say for sure. Let's see. Yes. So it was mailed and emailed and delivered this day, 8th of October, 2024, to Lane Jeffrey Myers. Signed Matthew A. Walker. So he wrote this and filed it with the court. And the document is motion for an examination of defendant's competence pursuant to Arizona Rule of Criminal Procedure 11.2. So he filed that, and then he has given testimony in this case, and I believe that was on the end of the second day, or first day, the end of the first day. He goes and he says, well, I don't know Lane Myers. I don't know what he's capable of. And therefore, he is a safety and security threat. Based on his motion, which they never did a competency in Pima County, which I think is actually grounds under, I think it's Jackson. If there's any indication of mental illness and they did not do a competency, everything can get thrown out on that alone. Even if he ends up being competent, found competent, they have to have the hearing, especially since they already filed a motion for examination of defendant's competency in front of Judge Royas. So that is more than basically there's constitutional protected class animosity being represented in the court. And that's what Matt Walker means by, I don't know you. I don't know what you're capable of. I'm not going to say it, but I'm scared of you because I think you're crazy. I think you have this mental illness, and therefore it's reasonable for me to discriminate against you and claim that you're dangerous and scary and a security and safety threat. Now that would be a violation of 42 USC 132. And that is the enforcement and core anti-discrimination provisions of Title II of the Americans with Disabilities Act. Right? So there's indication that everything that they're doing is because he is mentally ill, and I don't know that for a fact. I'm not a psychiatrist or a psychologist, but I can just depend on Matthew Walker's filing here, since the rules mean that since he filed it, he believed it and had a good faith belief in it, and I can just incorporate that. I don't have to go any further with my own analysis. Although I did post one video that said Lane Myers was full of crap, and the way that he is yelling at the judge is just absurd. Like, I mean, the definition of disability is a mental or physical condition that impacts daily life activities on a long-term basis. That's literally what the 88 protects. It's that broad. And for him to go into a court hearing and not only record it and live stream it against permission and all that, but then I think the judge's name was Kathy, and he just starts yelling at her, and he's like, she denies his motion and actually says why. Not, I mean, judges are never quite clear, and you don't get a long-winded explanation, but she actually says why. Versus Metcalf in my, motion to record, he actually doesn't say why, and it's not on the record, and it's required to be on the record. But what he just says is he's already decided, and nothing that I have written will change that. But that is not how it's supposed to work. I had a completely different argument. My argument was based on the integrity and appearance of justice standard. It had nothing to do with media. I am apparently now media, but damn it, I never wanted to be. ReallyCoolNews just kind of, screwed up my privacy there. So there's more to this than just not, he never made a true threat. The worst part of it is they're implying that he's dangerous because he's mentally ill. The specific fact pattern here, a voicemail announcing an intention to speak. And I think it was Fisk. No. That's not it. What Supreme Court case said the state can regulate protests on a personal evidence. I should find it. Frisbee. Frisbee ruled that because a home is a sanctuary and you're supposed to be able to go there and enact peace and relaxation and blah, 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 it's a special protected environment. So you can't protest somebody's house. But if you read the actual opinion, where they stopped short was you could still picket through the neighborhood and you could still engage in activities, you just couldn't siege the house. So you could still walk through the neighborhood, you could still talk to the neighbors, you could still give them pamphlets and stuff like that. So the two main things I've heard against Lane Myers is that they basically said that he called up his wife and said, I'm going to come down there and talk to you about what a piece of shit your husband is or whatever. Not the best way to get an interview, but there's no true threat. There's no reason to be in fear of this person for saying that he wants to interview you, unless you believe in, discriminating against mentally ill people. They're all dangerous because some of them are dangerous, right? But we don't do that to races or religions or anything like that. Only the mental health label allows you to discriminate anymore. So a heckler's veto is basically what the state brought. They found somebody who said that they were fearful. I'm scared. Why are you scared? And, well, I'm getting emails that I don't like and weirdos on the internet. Well, that's everything now. Like, literally, If you're on the internet at all in any type news, you'll get all kinds of comments and contact, and a lot of it is not welcoming. Right? You're an idiot. You're an asshole. I hope you die. Blah 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 blah. All that kind of stuff. Just massive amounts of crap. Like, I was always a fan of the internet. I thought it would solve problems, coordinate people, and bring them together. In my later years, I realized that putting 7 billion people in the same chat room is about as dumb as it gets. So, the charges amount to overloading, um, discrimination of a protected class, heckler's veto, violation of the NAACP versus Claiborne, which said that ridicule and basically harassment was protected activities, and that case is still positive law. It hasn't been diminished. Grand jury. So I go on and on about basically how bad this looks, how it chills speech, and how the plea, there's no factual basis for the plea, because what they did was they never considered legitimate purpose. They just took the state's assertion that there's absolutely no legitimate purpose ever to contact the wife or the spouse of a prosecutor if you think that they hold a position politically corruptly. And that's just not true. The collateral bar doctrine does not apply. The message this prosecution sends to every observer, and why this court must not let it stand unexamined. And as fast as they denied all this stuff and removed it from the docket, I'm pretty sure they didn't even read this. And then it brings up my own case where I was basically charged for protesting the UPS store. Lackluster did a expose on it. Brady material destroyed. So I'm setting up a foundation of how that office is corrupt and they like to conceal information, and that way they get to control the narrative. And then you have idiots like ReallyCoolNews or Jimbo the bimbo, basically acting like justice was served, because the way justice works now is the new mob mentality. Basically, a bunch of people with pitchforks with indignation means that you're guilty of something, right? So, and the reason why I go over all this nonsense when I said this was about the two hearings is because that is exactly what they're doing. The first whole day and most of the second day has all been about stuff that they can't prove, don't know when it happened. Because they have these videos and they claim, well, this video shows that Lane Myers, communicated with, this is a public service. But it doesn't, because like the defense attorney keeps saying, what really happened there was entertain the dark, or I forget the name of that. Illuminate the dark. My bad. I'm sorry about that. Illuminate the dark. Got a video. I guess it came out in court that it came from a coordination with the defense attorney. So the defense attorney basically got this case and then got disclosure and was like, holy shit, I've got 500 hours of video, and I'm exaggerating here, but not by much. Definitely over 100 hours of video. I've got all this video content because, you know, my client is a YouTube star, and so I need help going through these videos and figuring out what's what, and if there are any violations and what we need to be concerned with. And so he apparently coordinated with either the girlfriend or the ex-wife. I don't mean anything. She was on stand the first day after the probation officer, and she just seemed to indicate like that it was a very strained relationship, and that Lane had taken a cash advance without talking to her first, and that she had lost her judgeship at the federal courthouse in Tucson, Arizona. And I wish I knew the name of that judge. I really do, because I'd write her a letter that she was completely wrong to abuse her office that way. Now, the girlfriend kind of conceded that Lane Myers was responsible for her getting fired. But she also said that somebody in the prosecutor's office communicated that. And so, yeah, I mean, even if you go full in on Lane Myers as a jackass, okay? Let's just for a minute say that that is true. Kind of like Larry Flint was a jackass with Hustler magazine. Let's just go ahead and make that a given. Why punish her now? Like, since when in this country do we have a guilt by association? Like, I'm married to an asshole, so I can't have a job? I don't think it works that way. It's not supposed to work that way. I don't think it's equitable for it to be that way. And I would tell any federal judge that fired this woman because she had a relationship with an asshole that she should check her ethics in employment practice. So, basically, we have the first day, and the first half of it was a witness named Wayne Keatley, and this guy is all there. He has a long history of being a police officer. Now he's a probation officer. He's a straight shooter, a good guy. He's just doing his job here. And he did not pull any punches or anything for this prosecutor. He doesn't know. He doesn't really care. He was subpoenaed. I mean, he cares about his job, but you got to keep in perspective. He's got 200 people that he supervises. Some of them are murderers and rapists and stuff like that. As far as he's concerned, Lane Myers is nowhere near the top of his list. Top of his concerns, none of that. So, basically, The first half of the first day, if not more, was the prosecutor trying to get this guy to, say that Lane Myers violated. He violated, and how he violated, and which video did he violate. And the guy's like, well, I don't know much about computers, and I don't download videos and archive them, and I don't have time to watch all the videos that Lane makes, and we don't have the resources to do all that, and etc., etc. They could have just bought a $20 YouTube premium account, and then they can use AI to search his videos for keywords and tags and stuff like that. And that's what I do when I, put really cool news crap on my channel. Make it as short as possible. And, they just went round and rounds with this guy. And then, after all that was done, they basically went the other way with cross. And then they had redirect. And then the judge said they were supposed to be recross, but magically the judge eliminated that because supposedly somebody was streaming the hearing. And that is so important not to allow that. Even though her name, Shannon Walker, hasn't been mentioned once in the case. They make it a big deal, and I showed already in this video how prevalent her name is. So, it's just there, it's out there, it's permanent record on the internet. What are we gonna selectively arrest anybody who says her name? I guess I'm in big trouble then. But I have to make the argument that I'm trying to make, and that's that the court trying to protect information that's already out there is not a legitimate purpose of a standing of an order. It doesn't make any sense. They're not doing anything except for concealing what the content of the hearing is. And so this guy here has no information. He basically said that he wrote the violation order because his boss told him to, and he wasn't privy to any of those conversations. So he don't know why he was told to violate Lane, but he did because he was told to. And so there really is no evidence there. And then after Wayne Kelly got done as a witness, they put Mr. Matthew Walker here, and this is one of the nicer images with the Pinocchio nose here. I find it 100% incredible that he would act like on stand that he has no idea why somewhere in June Lane started talking about his case again, even though he is the one that made it an issue at the Supreme Court, and then the APAC made it an issue at the Supreme Court in petition R-26-0003. I guess we have a helicopter flying overhead. So for him to act like he doesn't know his own involvement with the Supreme Court petition for rulemaking process, I just find that completely disingenuous. I would go just shy, maybe right at the line of perjury. And now that we've talked about Matthew Walker's petition to have Lane Myers evaluated psychologically for competency, we now know what the whole point of all this is. To attack and remove mentally ill people from society, and that's what Matthew Walker's engaging in. And that's what his testimony consisted of. The prosecutor asked him, basically, and all this whole hearing is completely irrelevant at this point so far. The entire hearing should be verbatim. What are his bond conditions? What activity violated that? And it should be clear, which is why the rules allow for 20 days, and you're supposed to have arraignment within 7 days of the bond violation. And then from 20 days from that arraignment, you're supposed to have the actual bond violation hearing. It doesn't really contemplate a multi-day hearing on this, because it's not supposed to be that complicated of a matter. You have a bond condition, you have a proposed activity that violated, and then you have a determination of if it violated. And so what Judge Metcalf is doing here is he is allowed, for some reason, he sat on the original case, so this doesn't really make much sense at all, but for some reason he's allowing the prosecutor's office to lay down a foundation of how he got convicted, which is really simple. He was charged, pled guilty, and received probation. So, there really is no background, except for what they want to do is talk about how Lane is dangerous and a security risk, and why, they needed the bond conditions. All of that's irrelevant. They have them. And the defense attorney goes after this. Why is he? Why are you scared or fearful? And Matthew Walker said again, he doesn't know Lane, doesn't know what he's capable of. Well, that's any human being you don't know. Literally, Matthew Walker can say that about me, can say that about Toe Tag, Tucson. He can say that about Judy Ain't Got Shit. He can say that about absolutely anybody. It's a meaningless standard. What this case is really about is they are trying to make this go away. It started to hit more media than they would have liked, and it started bringing up corruption in their offices, in the prosecutor's office, and he started streaming it online. He only has 15,000 subscribers, and I say only because I have 300. So if he only has 15,000, I nearly have 0. Anyway, so and that's what the sequestering of this hearing is all about. I use the word sequestering, but there's no audio allowed. So when the defense attorney says objection, and then says attorney-client work product, I spoke to these people as part of me representing Lane, and then the judge rules on that within seconds. You get the impression that he's not really considering anything. And the first day must have been 20 objections by defense. And I think maybe one of them was sustained because basically was asking, Matthew Walker had started basically narrating instead of answering a question. He was being asked open-ended questions, and the prosecutor was allowing him to just babble on and on and on as a response. And the defense attorney, Resnick, objected to that, and that was sustained. Not that it mattered much, the whole procedure was about talking about what happened in 2004, 2005. Like, what does that have to do with the violation hearing? Well, what it has to do with the violation hearing is this guy actually sits on the juvenile court. He's the presiding judge. So he has a lot of activities there and a lot of duties and responsibilities there and a very tight schedule. And as he said, everything to do with a juvenile case has 4 attorneys or more, because you have a guardian ad litem, you have the actual attorney, you have the prosecuting or the other side attorney, and I think he's talking about probative too. So you have all this complexity on moving a hearing. It's very difficult. So they had one day on the 11th, and they consumed that with nothing, and then Metcalf pulled out a trick to get the 13th, which was the second hearing date, and they ran that up for nothing. They didn't even go till 5. They ended it at 4:30, 4:20, 4:30, whatever. And so they consumed all that time for nothingness. And now he set the next hearing date at September 14th at 11 a.m., which I'm thankful for the 11 a.m. part, but that just shows how much time is being wasted and not used. And that's going to require Lane sit in jail, even if he's ultimately found not to have violated. He's still going to have 60 days of jail time. And so that's the plan, and the prosecutor is definitely in on that. She has made assertions in court to the judge that the history is relevant for some reason, and that overruled Resnick's objection of relevancy. And so on and on and on. We're talking about the past. I will say, on the first day, they played a lot of Lane's videos, and it was surreal. The portions they took were about him playing music and singing along and rambling, kind of like what I'm doing now, rambling, but worse. I would say a lot worse. And so we covered, that's the whole probation. The second day was entirely this guy testifying as a witness. And the funniest thing about that is he has no first-hand information on anything. So he's testifying about videos he's watched, their name, and his determination. But his determination isn't worth anything, because when asked directly by the defense attorney, he feels like Lane Myers is forever forbidden, or at least in the next 2-3 years or whatever while he's on probation, he is forbidden from uttering the sounds Shannon Walker. And I will admit, Lane is an idiot for trying this, but this is a Shannon Walker, and he has this person's image and name on his video, right? And obviously, this is the same name as the victim. Uh, I think that is a dumb move. Uh, I don't think it's a violation of probation, but it is poking the bear. And I apparently can't spell athlete. And he also had this Shannon Walker on another video. And this is a guy, and so, um, Matthew doesn't think that that matters. Who he's actually talking about, as long as it sounds like his wife's name and he's talking, somehow that's going to lead these people to his wife. And this is her information. So they're not trying to conceal who she is. She's not trying to be a private person. And they go on and on about the technicalities of how she's not a government employee because she actually works for a nonprofit to raise money for the university and doesn't actually technically work for the university, although she does have an office at the university and works there, right? So on paper, she doesn't work there. In reality, she works there. And this poor woman, I mean, I'm even talking about her, but she does do good work. She's a respectable person. She raises money for a college so that the college can have programs and function. And it's unfortunate, like, everybody's for Lane Meyer's wife or girlfriend being fired at the federal courthouse. But nobody's for her suffering because her husband is a douchebag. You see the disconnect there? Just because he's a prosecutor, he's somehow above reproach. He can't possibly be a douchebag. Well, I disagree. I've listened to him speak now. I've looked at his behavior in this case, and he is definitely a douchebag. I mean, if he is really fearful, then the last thing he would do is file a petition with the Supreme Court of Arizona and reference that case. There must be dozens of cases and examples and stuff that have nothing to do with him or his wife or this matter to bring forward to the Supreme Court, just like why they superseded it in a task force. They replaced his petition completely with their own, and they didn't mention the case or Lane Myers whatsoever. But then you have the APAAC that, on like the fifth reply or comment on the forum, then brings all that front and center. And in June, I sat there and watched Lane Myers meltdown on YouTube. And he was literally posting videos while he was reading these comments, using his case to try to remove the ability to record. Now, they act like they're not doing that, but they're expanding all the reasons why you can disallow recording in the court. They're up to 8 different separate measures where, I mean, the judge has already ruled in this case you can't record, all because there is a victim. Well, what criminal matter besides drugs, right? There's drugs and possession and transportation and sale of drugs. But what other criminal matter doesn't have a victim? Theft, burglary, assault, battery, harassment, stalking, all have a victim. So if the fact that there is a victim gives rise to not allow recording with personal recording devices as a disruption in the court, then Rule 122 and 122.1 or Section H or whatever is irrelevant. It's meaningless. Because in all cases, you're going to have a victim. So all anybody has to do is say that, the victim is concerned. And so that is a disruption. And boom, there's no recording anymore. And again, I don't mean to suggest that that's anything on Mrs. Shannon Walker. I think she is in the same boat as Lane Meyer's girlfriend. I think they're both two respectable women that love a douchebag, right? I mean, of course, the difference here is she gets no relief. Lane Myers' girlfriend gets no relief. She lost her $100,000+ a year job, and she doesn't get any victims' bill of rights assignment as the victim. She doesn't get any recourse, nothing. She's just out. Whereas this douchebag's, and I'm talking about Matthew Walker's wife, gets a temporary restraining order, and anybody who harasses her is immediately arrested, and blah, 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 blah. And you people that send her bullshit emails like anything negative, I mean, fuck you. You're a complete dick, and I definitely hope that they find you and charge you with I don't know, something, harassment maybe. There's no reason to contact her. She has done nothing wrong. She filed a temporary restraining order and got it. That's on the court. The court should not have issued that temporary restraining order, but it did. So that's on the court. And I can completely understand that, because if you look at what kind of documented chaos has YouTube created for victims and private persons. Let's see what YouTube comes up here with. So it's well documented. You have audience stalking, re-victimization, AI generated exploitation, and fake true crime. You have doxing and defamation rings. You have the entirety of ReallyCoolNews and their creepy Discord server that they're talking about in court. This coordination and attacking of anybody who isn't on their side or doesn't agree with them, which I am one of those. That's why I'm doing what I'm doing now. I got dragged into this online shit, so I had to pick a side between ReallyCoolNews that already thinks I'm a douchebag and hates me, or the other side, which I'm not even sure what consists of. But I chose the other side since, I'm actually on the side of the integrity of the courts, appearance of justice, and that kind of thing. I have never met or spoke to Lane Myers. I don't know him. I think a lot about him in the same way that Alan and People versus Larry Flint talks about Larry Flint in the end. Uh, Larry Flint's trying to get Alan to go to the Supreme Court, and he's like, I'm not gonna take you because every time I go into court on your behalf, you fuck me over. You turn it into a circus, and my attempts in court are watered down by your theatrics. So I'm not gonna go to court. And then Larry's like, well, you always said that the protection of the law protects pigs as well as presidents. And Alan goes, well, nobody fucking likes a pig. Nobody's gonna help a pig. And nobody cares when a pig gets screwed over. And that is Lane Myers. I mean, do I think what he did was illegal? No. Do I think what he did was admirable? Also, no. Was it respectable? No. But then again, that's how news works. What if the story would have been different? What if this guy would have been every bit of douchebag I think he is? And what if his wife was starting to think that, and they were near divorce, and Lane Myers contacted her under that situation? She might have had all kinds of things that she wanted to say. And Lane Myers had every reason to test that and find that out. Of course, that's not even his argument. He argues that she's a public employee or something, so he's allowed to, I don't know what, yell at her and stuff because she works for the government. And that might be true. She might work for the government irregardless of what the paperwork actually says. But, I mean, she raises money for a university. I mean, unless you have problems about how the university spends the money, or she's not a decision maker in anything to do with the Tucson City prosecutor here. Lane Myers should be trying to levy the mayor of Tucson and the wards, the council members, to recall him and remove him from his office if that's what he thinks, and he's corrupt. And I do think a lot of his motives lack ethics. I mean, you're going into court now saying how Lane Myers talking about the petition that you filed and instigated is talking about the case, which is a violation of his probation. So, I mean, it seems like entrapment if you really think about it. And, I mean, that is the first 2 days. I'm not really forgetting anything important. It's all about backstory and how we got here and why Lane was charged, and that he pled guilty and then was subsequently found guilty in a conviction of 2 felonies, and how he called this guy's wife, and how that's what they've been talking about, right? And it should be really, really simple. And they shouldn't need 10,000 videos to do it. And, I mean, Lane is doing jailhouse interviews and stuff, so they're just adding more and more on it. But he doesn't say her name. And when he does, it's that crap I was talking about with the astronaut and the athlete with the same name, that kind of nonsense. And they want to get him on a technical violation. They didn't do anything to try to curb his behavior before they violated him, which the probation officer said was discretionary, but policy. So the question is, what about this case uh, removes that discretion. So he manages rapists and murderers, people who have stolen, stabbed. Maybe, let's see, they said that Mrs. Walker had gotten a couple hundred, and we'll round out, so round up. So 200 concerning, uh, defamatory, unpolite emails with maybe a couple dozen being considered threatening, which I haven't seen them. So, based on Mount Walker's opinion of if an email is threatening or not, I wouldn't just defer to his judgment at all. Especially since he thinks it's a violation to even mention the case, because if you mention the case, then people could do research and find his wife and contact her. Well, they could also do that from the APAC site, right? Because there's her name on there. And they could also just search Google or talk to AI or, read his petition to change the rules. Or if the rules are changed regarding recording, for decades to come, as long as the rule has been changed, the process that was used to change it will be documented by the court, because that's part of the integrity and the openness of the court. So I mean, he should have withdrew his thing there, because he's being tied into the rule. And then there's the demeanor of Mr. Walker. He doesn't strike me as a person that is actually scared of Lane Myers. You can tell when somebody's scared of another person. They consider him a safety threat. They avoid that person. They avoid instigating that person. They avoid activating that person. They avoid animating that person. They de-escalate as much as possible with that person. Matthew Walker does none of those things. In fact, he does all of the opposite, right? So he says that Lane Myers is a safety and security threat because he doesn't know Lane. And since he doesn't know Lane, he doesn't know what Lane's capable of, which again could be said about anybody that Matthew Walker doesn't know. And he doesn't talk about how he filed that motion for competency evaluation of Lane, but that's what he's saying, is Lane is mentally ill and therefore he's dangerous and therefore my wife is at risk and this is a security and safety thing, and I believe that all mentally ill people are loose cannons and dangerous and blah blah. That is a straight up just prejudicial stereotype. Now, he doesn't verbatim say anything about Lane's known to be, and that's what the ADA protects. Americans with Disabilities Act protects anyone regarded as disabled. So you don't even have to be disabled. All you have to be is regarded as disabled and then discriminated against, which he is doing as a prosecutor, as a witness, and this whole prosecution is like that. So they charge him in 2 city cases on some misdemeanors. They try to move it to Pima County and they try to get him evaluated, but instead it gets dismissed. And then they bring these charges actually in Pima County with felonies, and magically, lo and behold, now that they don't want to use the mental health examination and forced treatment as like a punishment mechanism, now there's no mention of his mental illness. There was no evaluation done. They were in the correct court that had the rule to perform the evaluation. They could have done it from day one after they charged him. It did not happen. If anybody has any evidence to that contrary, I would like to know. And that's Matthews, too. There's a Supreme Court case called Matthew versus something or other, and they found that it is a violation of due process and a person's rights to convict them if they have some sort of mental defect. And this person filed, and keep in mind, when you file with a court, especially as an attorney, like in the federal districts, you have like Rule 11. The state is going to have something very comparable, and it might even be Rule 11. I just don't know it right offhand. And it says that when you file something, you have done an investigation and you have a good faith belief in what you're saying and what you're filing. So if he filed a motion to challenge Lane's competency, then he believed it. And nothing about Lane's behavior has changed since he filed that 2 years ago. If anything, Lane's behavior has gotten worse, or it got better and then got worse right before they violated him, according to them, because they said that he had been following the terms. This guy also doesn't know the difference between a public YouTube video, like this is, an unlisted YouTube video, like when you need the link to find it, and a private YouTube video, which is like you using YouTube as cloud storage and no one but your account can see it. He testified that it would come up and say this video is private, and so he testified, you just needed a link to view it. That is not how YouTube works. Now in Google Drive, you can share access and provide a link, and then you can control access by links and then add accounts. But, I mean, even if Lane was doing that, and that is not part of the YouTube system, that's Google Drive, he would have to give all 15,000 of his viewers or something access by email, and it would be a nightmare just to manage access to the account. Like, it made no sense. But he wanted to point out that, the order and the probation conditions required Lane to remove these videos. And he felt like he hadn't done that just by making it private. And he stated multiple times that anybody with the link could view it. And then he was so stuck in that, so determined to hold that position, like he couldn't even admit that he was wrong, which is why I think he was intentionally lying about it, because he said he had a list of links and then it was made private and then all you needed was a link to view it. And the defense attorney is like saying, well, if you had the link and you're clicking on the link and it doesn't load, doesn't that show to you that that's not how it works? And this guy just kept on, no. It has to be a different link or a special link, or I don't know what a link is. And it's actually a URL is a universal resource locator. So, I mean, like if I click on this here, right, the protocol is HTTPS://. That means hypertext transport hypertext transport protocol secure. So this is port 443, and I can prove that by giving it a specific port. Maybe I'm wrong on that. It's been a while since I've done I think it's supposed to be 443. Anyway, so that is the part of the universal resource locator. So you have the protocol, and then you have the domain name. The domain name translates to an IP address through something called domain name service, or DNS. And so that is converted to an IP address, which is technically between 255 with 4 segments. So, like most of the time, your home IP address is 192.168.1 dot, and then like 110 or something, right? So up to 255, 4 segments. And that was expanded in TCP/IP 6, which went from 255 4 segments to a lot more, which is why nobody uses it, is because it is completely overkill. And they've tried to create all kinds of tricks and stuff where you can abbreviate whole segments and subnets, but nobody uses that. I mean, I don't use it. I don't even bother to make sure it's enabled. I think this is kind of interesting, I find it unique that ChatGDP would agree with me that Matthew Walker is a dick and would put this wooden Pinocchio penis as a nose with testicles on his forehead. Because normally I would think that ChatGTP would have like some sort of safety or policy restriction or something like that. But it did do that. And see, it's talking about the petition to amend Rule 122, the use of recording devices. He's the prosecutor, the petitioner, the witness, the makeshift victim. Like, he really is a makeshift victim here. He's not technically classified as a victim, but he tries to act like the victim and inherit the victimhood. His wife has definitely been victimized. I don't think by Lane Myers. I think because the internet is a gigantic, massive toilet with douchebags like, really cool news, dude. I'm Jimbo. Yeah. Basically, you put anything out on the internet now, and you're going to send massive amounts of people to hate you, right? And this is the home of the toilet, right? You have the absolute toilet. This used to be called Twitter, and you used to tweet on here. Now it's called x.com, which means, I guess, you're crossing, Xing, not tweeting, but Xing. This is my Arizona AI regulatory project, trying to create documents that teach and organize the reformation processes of artificial intelligence. And apparently that's not a big deal because 1,000 people have seen it, and 3 people bothered to click on anything. And you'll see in here that I basically argue with a bunch. Well, I used to really like generating AI images. So there's a lot of that on here. But you'll see, like, any notifications is all toilet. If you comment on anything, uh, you just get attacked. Oh, this guy's in jail, I think. According to ReallyCoolNews, he is another activist.
Mouth of another seated council member.
But he is so outrageous with everything that he just undermines any First Amendment auditing activity. And I know they like to call that frauditors, but they don't call it entrapment when the police do a sting, right? And I mean, back when Uber got started and Lyft, I mean, we're talking high-tech sting here. They would install the app, they would hit the button, and whoever showed up, they would arrest and impound their car for illegal activity. And I mean, you could literally do that all day long, dude, with no ability to actually do any law enforcement work. I mean, it's worse than a roadside thing. You're sitting there alongside the road with radar. You can get people all day long. And it's even worse than that, right? So everybody thinks that's fine when the police do that, but when the citizens try to enforce the law as a civil authority, which would be like in the Declaration of Independence, would be like your duty, then all of a sudden you're a frauditor because you're really not auditing anything. You're just, I don't even know what the fucking argument is. It's just this divisional politics. You have people that are red, white, and blue, no matter what, and that's not healthy. If people can't question their government and can't verify that it works the way it's supposed to, which they're really going to hate my entire arguments about the appearance standard, and they're not my arguments. They're ancient, and they're well-established law. That's why under the canon or the rules of ethics for judges, a judge can be punished just for appearing to have impropriety. You don't have to prove anything. You just have to appear. You just have to demonstrate that it appears that there was impropriety. And I mean, I think I've beat this one to death here. I know you got Judy Ain't Got Shit, or Judy, I Lost It Years Ago. She narrated and dramatized and gave the state is right and Lane Myers should go to jail for years and years and years. Like, this is how we throw people away now. People are just useless and worthless, and you don't have to work with people or concede anything or nothing like that. You just, if you don't like it, you call the police, and then the police pick a winner. And as long as you got the female attributes and you're the N-type narrative crowd, the police are always going to pick you as the winner. So, you must be right because, shit, if you lived a century and a half ago, these are the same people that would be talking about slavery and how great it is. Now, they'll act like, no, 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 not me, not me. But no, if you go with the flow and you buy the narrative on what is prevailing wins, then and that's what these people do. Then you, at the time, would accept racism and slavery, and you would be there for the Dred Scott opinion, and you would be against Lincoln. I recently had an argument with somebody. They said, well, nobody ever did what Trump did and incited violence like that. I was like, are you kidding me? You haven't heard of Abraham Lincoln who incited a civil war? you, you gotta be kidding me, man. And then as soon as the President of the United States does it and people follow him, where is the militia? Right? Why wasn't that protected by the Second Amendment? And they don't need weapons to do that. It says a militia being necessary for the. Well, let me get this straight. So nobody's like, oh, you don't know the Second Amendment. And no, I can't recite it verbatim. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, the militia isn't the same as military, but it's still commanded by the president in this country. So when he fucking assembles it, anyone who shows up should be protected by the Second Amendment. So if you think January 6th was right and they were supposed to arrest all those fucking people and round them up, 5,000 of them all around the country, you're an idiot. You don't actually believe anything in law. You're an authoritarian. You look at the suit and the uniform and you judge correctness by who says what. Not the reasonings or the logics behind it or the outcomes. Nope. Just somebody you think has authority of logic told you that January 6th was so bad and blah, 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 that, we need to go into special actions and stuff and go after all these people. Nonsense. And I'm pretty sure the guy that never got arrested was an FBI guy instigating a lot of that. I like this one, the bullshit. She got horns as a pile of shit. Yeah, she's completely full of shit. If you're listening to anything she reports on Really Cool News, she dramatizes it. She gets things wrong. Let's see. I made a petition, and I think it's not online. Let's see, we got Randall. Been talking to Mr. Finch and his lawyer. And I think they wanted. No. Motion for recording. They wanted this. And why not give it to them? I filed it. So this is my motion to record. And the judge didn't consider it at all. And she describes this of, I tried this 3 different ways. No, I didn't. I tried it once. Appearance standard. And what is clearly apparent is the judge never read this. And, I mean, maybe you can say, oh, well, it's 24 pages. So he didn't have time to read it. Okay. Well, it's still standing. Right? That was the hearing ended Tuesday and went into Thursday, and I filed this Wednesday. The hearing for Thursday was set on Tuesday. So, I mean, how was I supposed to do any better? And I've gotten lots of contacts from a lot of people since posting, I believe it was this video here. Ever since I posted this one, I've had people contacting me both through messages. There we go, comments. I accidentally uploaded this video on 2 different accounts, so that might be a problem. But yeah, so like, I so don't give a shit. Here's my inbox. And I mean, all these people are mailing me. I got a bunch of shit going on, but I don't care. LexisNexis. I actually won against the insurance company. They put me down as at fault collision when my tire blew out. And I actually beat them on that. And they reclassified that as not at fault. And they reclassified that as not a collision. It's now under comprehensive coverage. So that's pretty much my reporting. Can't wait for you guys to all talk about my emails, which this has nothing to do. My emails have nothing to do with what I'm trying to report here. And like I said, if ReallyCoolNews didn't oust me and do all that shit, I would have never posted a damn thing. And to prove that, I have multiple accounts on YouTube, and they're actually all under the same account. The last time I thought about making anything to do with posting on YouTube was for that AI project, and I didn't even do it. Because if you go to your channel, I set this all up and never did anything with it because I couldn't go live. When you try to go live, it just, you can't do it unless you have so many subscribers. So whatever. I didn't do that. I haven't posted. And then here is my other YouTube account. And if you go to my channel, I posted 3 days ago on this. I posted here, and I streamed something about Lane Myers being full of crap. And the last one before that was when I tried to basically talk about the craziness, which is the sovereignwar.com, and is what I've since lost that domain name because I stopped paying for it. But I started this channel about the sovereign wars 2 years ago. I had Lenovo charger problem. Basically, I use YouTube to bitch about quality assurance and stuff like that. I'm not a YouTuber, so I would not have posted any of this shit had Really Cool News not attacked me online. And this is what I covered. Really Cool News. So
Well, this is allegedly
no, it's not. It's not allegedly. It's a bunch of lies.
of the probation officer, then Lane's what no longer off.
And drag your name through the mud, and process there would have been
that is the one sitting right behind Mr. Myers to make sure he doesn't pop off. Who then says, "Judge, I need to speak with you." That's when we find out that allegedly Jason Jensen is streaming.
Well, allegedly doesn't cover you. I mean, if it did, I could say allegedly anything about this woman I want. Allegedly this, allegedly that, allegedly she's a douchebag, allegedly she has no journalistic integrity. And I can say those things because those are my opinion. But I could say allegedly she's a pedophile, allegedly she's an embezzler, allegedly she, eats little puppies. Allegedly. Yeah, allegedly doesn't cover anything. You can't violate somebody's reputation and just go, well, I thought I said allegedly, so it's all good. Allegedly, right? Allegedly. I just add allegedly in front of every sentence, and I'm allegedly good. No, that's not how it works. But they took this video down, and they retracted it, and they ran a retraction, and then they made another mistake, and they basically said that some court officer told them that, and that's what they were going off of. Well, we're going to find out what officer did that, because I have contacted the court, consumer relations, on all that. Find out which court officer decided to slander my name and bring me up in this nonsense. Although I don't really necessarily believe these people.
Mr. Resnick was like, well, and tried to get into an argument with me about.
Like, see, she dramatizes this. And I talked to a lot of people in the courthouse. I talked to the parole officer, Wayne. I really like that guy. I don't really necessarily get along with authority, but I really liked his attitude. I liked his honesty. He wasn't willing to pull any punches for the prosecution. He stated what he knew, and he stuck to it. If he knew something, he said something. If he didn't know anything, he didn't know. So like I said, the story really is that the person behind her, which she somehow confused with me, even though that was a female and I'm a male. So the person behind her phone rang, and then that person tried to get my help on figuring out her cell phone and watch combination, which I didn't know nothing about it, didn't want to get involved. And that is who the police officer apparently needed to talk to the judge or whatever. I saw that, but I didn't. There was no voice or anything that she could have heard. The judge doesn't. When the bailiff or the security guard for the court goes to the judge, you can't hear nothing they're saying. Right? So she's acting like she heard what he was saying. You can't hear it. Unless, unless she's got eagle ears, right? You can't hear it. And sometimes they even put on the static machine, so you really, really can't hear it. I don't care who you are. So her pretending like she knows what's going on here and then referencing my name was all misinformation on purpose to defame and get me in trouble. So it never happened, and I have an email to community relations at the courthouse to find out if any officer said I did anything whatsoever, because I didn't. And then when we went out in the hall, like I said, I asked her if she wanted to talk. And so I started talking to her, and then she does this attitude shit like, I didn't just say what I did, but why are you talking to me? I don't want to argue with you. I'm on the text messages and blah, 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 blah. Well, bitch, just fucking say that. Why lead somebody on when that's not what you want? Quite simply and seriously, why fuck around? Right? Just, okay. Oh, you're asking me if I want to talk to you? No. Instead, you act like you do, and then this is the bullshit that you report.
Oh, was he convicted versus did he plead?
See, this is the problem with this kind of reporting and why. Anyways, I'm not gonna beat this with a dead horse. All information provided herein on this video recording and broadcast live is under the copyright of I don't give a shit. So that would be like Creative Commons, non-attribution, or just flat out public domain. I just disclaim any of your use of it. I have no liability for anything that you do with it, and I don't know how it could cause you a loss or an impact, but if it does, I am not responsible for that. Otherwise, this video is public domain, and I do not give a shit about its copyright. So you can copy it, and you can tell other people to copy it, and they can copy it, and they can draw a big penis on my forehead and copy that, and copy the other thing, and copy, I don't care. The rest of it, any copyright that I don't own, this is fair use as commentary. Again, if you are an asshole and contact any name I've mentioned, including the judge, including the prosecutor, including the parole guy, including Matt Walker, including his wife, including anyone else, you're an asshole. Don't fucking do that. I mean, unless you have a good, legitimate reason to, right? Contact them, right? Don't do it. Definitely don't contact the judge. That's not how anything will ever work. If you email the judge, he is required by law to fucking ignore you. So don't do it. Make your own YouTube video and, scribble on the screen and bitch about shit. Do that. Don't contact anybody. I use names because that's who they were. Wayne Kelly. Don't contact him. Also, on a side note, don't fuck with him. He's an old school cowboy kind of guy, and he will whoop your ass. So don't fuck with this one for sure. Don't fuck with that one. You can fuck with her. Contact her all you want. Send her nasty grams. She is a media thing, and she likes to talk to people and stuff and then change her mind. So you can, I take it back. You can contact Judy You Ain't Got Shit online, and go ahead and tell her, that she ain't got shit, ain't got it no more. Do not contact the judge whatsoever. I might disagree with him. I might think that his rulings are bullshit, but he's still a judicial officer. Do not email him. I did not put his email up there because do not email him. This guy here, you're free to use this image, by the way. I can't even own copyright to it since it was AI generated. So you can use that one. And you can use this one. This one's a little bit nicer. I like how it has Tucson City Court. It's like the Supreme Court or something. Truth not welcome. Dismissed, not credible. Other than that, I'm going to end this after all my long disclaimers. Don't contact people. You're welcome if you're in the area to attend the hearing. Again, that's September 14th at 11 a.m. If the courtroom holds, it will be courtroom 802 on the 8th floor of Pima County Superior Court. You guys have a good one, and be smart about political activism. Don't be so outrageous that nobody can defend your position there.